Hello, good morning, everyone. Good morning, Taran. So, today we are to start with to discuss the Digital Information Security in Healthcare Act, its impact on mHealth vis-a-vis Personal Data Protection Bill 2019. Now, what is this mHealth? This mHealth, usually we would, in a normal course, we often refer to as the mental health. But here we are not talking about the mental health. We are talking about one specific thing, which is the mobile health. Okay. And now, since the Digital Information Security in Healthcare Act, that means we are talking about the digitalization of the healthcare services. Okay. The digitalization of the healthcare services would mean what? Okay. The digitalization of the healthcare services means that your healthcare services, you can have access to various healthcare services online. Okay. Okay, so there is a digitalization of the health. I hope I'm audible and visible to you, and the video is not lagging. Is it so? I guess there's some technical glitch. Is it so? Now its impact on, please tell me if there is any technical glitch. I guess there is some technical glitch. The video is lagging or the internet is lagging. What is happening? Am I audible and visible to you? Am I audible? Hello? Please tell me if I am audible and visible. Nikhil, okay, it is lacking. Okay. I don't know why it's happening. I think the network is all right on my end. What is happening? Why it is happening? Okay, let it be. I think it will fix by itself in some time. You listen to me carefully now. The Digital Information Security in Healthcare Act, its impact on M-Health vis-a-vis Personal Data Protection Bill. Now we are talking about the digitalization of the healthcare services and how far the M-Health is connected with the Personal Data Protection Bill. Because when we go online for anything, for to have access to any service, any kind of service, be it the healthcare service or be it the payment of money or any commercial transaction, we are talking about, we are, floating our personal data, our personal details in the on a web platform. Okay, now this creates a question mark. This raises a pertinent question about our personal data protection. Already Personal Data Protection Bill 2019 is already in place, and which is about to be enforced, and it also established data protection authority, that in some cases where there is okay, so I am audible, but the video has just stopped. Okay. I don't know why it is happening. Just give me a second. I'm trying to fix it. I'm trying to fix it. Let me refresh this page once. Okay, it's fine now, I guess. Okay, so the Personal Data Protection Bill 2019, I was saying, is already in place, which establishes data protection bill, and it has long elaborate provisions regarding the protection of our personal data online. So in this digital era, we are particularly talking about the M-Health, that is the mobile health, because we can have access to the healthcare services. Your medicines are available online. You can get your tests, like various tests prescribed by the doctor online. There are so many portals like M-Fine, Dr. Lal Pathology. There are so many path labs which have gone online. There are so many portals like PharmEasy, Tata 1mg. These are all the online platforms, online healthcare services. The doctors are available for consultations online. The doctors are available on PharmEasy also. Okay. So in this digital era, we are witnessing an unprecedented growth in technology. However, the laxity of the legal regime in catching with this growth in technology has made governments around the world revamp the existing structure for data privacy. In this attempt, the Government of India introduced the draft Digital Information Security in Healthcare Act 2018, Disha, for the protection of digital health data of citizens, which combined with the Personal Data Protection Bill 2019. Okay, this is known as PDP Bill 2019. So in this digital era, there is an unprecedented growth in technology, and what is lagging behind? The legal regime, the legal mechanism is lagging behind because it's not able to catch up with the growth in technology. So far as the fast pace at which the technology grows, exactly at the same pace the law should catch this growing technology to cover every single thing legally. Okay. What the present governments need to do around the world, they need to revamp their existing structure for data privacy. In this attempt, what the government of India has done, the government of India has introduced the draft Digital Information Security in Healthcare Act 2018, because there are two people with whom you share your personal details. Listen to me very carefully. There are only two professionals with whom we or you share our very personal details. Okay. Like, for example, a lawyer is a professional with whom we share our personal details. Okay. If something personal dispute is going on, God forbid, then will have to share this with some lawyer. Okay. If God forbid you are disease stricken, then definitely you are going to share it with your doctors. Okay. Or you are going to have some personal problem, you have developed some personal problems, so medical personal problems, then you will share those problems with your doctor. Unless and until you won't share every single thing in detail, then definitely the doctor won't be able to heal you or treat you properly. So whenever a person goes online or can consults a doctor or takes the medicines, he submits his personal details, his personal data somewhere online. So it is very important to address this issue, that Digital Information Security in Healthcare Act 2018. Like, for example, if you remember the case of Hospital X, Mr. X versus Hospital Z, that is a case in which the title of the case is also hidden. The actual parties between whom this case was fought, this is also hidden. Mr. X versus Hospital Z is just the title of the case in order to tacitly create a case law, while hiding the names of the parties so that the patient's name shouldn't be revealed and his privacy should be protected. Because in cases of HIV AIDS, the informations about the patient shouldn't be revealed into the public discourse. Okay. So it is important in these cases that there should be a legal mechanism to deal with the data protection or data privacy online, especially with regard to healthcare services. So the government of India has drafted the Digital Information Security in Healthcare Act 2018, which is in short known as Disha, for the protection of digital health data of citizens, which combined with the Personal Data Protection Bill 2019 gives a promising future for data protection regime in India. Now this is going to be combined with Personal Data Protection Bill 2019. What is the basic difference between Digital Information Security in Healthcare Act and Personal Data Protection Bill 2019? There are a lot of similarities between the two, because both of them are actually working and creating a mechanism for the protection of online data and data privacy. But these two have a very basic difference amongst them. What is that? Personal Data Protection Bill 2019 talks about and creates legal mechanism for the protection of all the general data online. Okay. But Digital Information Security in Healthcare Act is something Digital Information Security in Healthcare Act is something which is protecting only the personal information related to somebody's health. Okay, so this has to be combined with the Personal Data Protection Bill 2019, gives a promising future for data protection regime in India. However, the strict provisions in Disha related to the ban on the commercialization of health data and disparity with the PDP Bill 2019 have resulted in a conundrum which needs to be resolved. Okay, there is some conflict, between Disha and the PDP bill, because under the Disha or the draft Digital Information Security in Healthcare Act, there is a ban on the commercialization of the health data, and it is also not falling in conformity with the PDP Bill 2019. So this sort of dispute has resulted in a conundrum which needs to be resolved. What is M-Health? M-Health or mobile health. refers to the use of mobile technologies for accessing healthcare services. Now, we usually, when we say M-Health, the first thing that strikes our mind is mental health. But here we are not talking about mental health. We are talking about mobile health. Okay, mobile health refers to the use of mobile technologies for accessing healthcare services. The services could be ranging from as simple as receiving text messages related to health services to that of using complex technology to analyze your health data for better services. So what is M-Health? That is mobile health. Okay. Okay, mobile health refers to the use of mobile technologies for accessing healthcare services. The services could be ranging from as simple as receiving text messages related to health services to that of using complex technology to analyze your health data for better services. We often receive certain messages from various apps like Tata 1mg, like PharmEasy. Like if you are going to purchase some medicines from PharmEasy, and if you are going to purchase some medicine from Amazon, it will keep sending you the SMS. It will keep sending you various messages regarding health services, that what other health services are available on their portals. Like for example, I bought some medicines for my mother from PharmEasy and Tata 1mg, and they keep messaging me since then that they have these kinds of services. If I want a doctor, they can also provide a doctor online. So these kinds of things, they keep sending me messages. So I receive those messages. I read those messages, perhaps to know that how far these services are available on their various portals. Now, we are using complex technology to analyze your health data for better services. Like for example, when I bought some medicines for my mother on PharmEasy, okay, on Tata 1mg also. So they demanded prescription, and in prescription every single thing is written. What she has been diagnosed with, what are the medicines prescribed, okay, what is the diet plan prescribed by the doctor. Every single thing is written in the prescription. The prescription was uploaded, it was then verified. After its verification, they confirmed the order, and then the order was delivered at my home, at my doorstep. Using these kinds of complex technology to analyze your health data for better services is very good. But somehow we shouldn't forget that we are sharing our very personal data with somebody whom we have not seen. He's just on the other side of sitting on the other side, and he's not even visible. Okay, so there are various examples of innovative technology, such as wearable devices that use mobile technology to analyze and interpret health data. Considering the rapid technology to analyze and considering the rapid transition to the virtual world, it is expected that this industry will progress at a very fast pace. Now, since there is a rapid transition to the virtual world, everything has become so virtual. Earlier the coaching classes and the physical classes used to be the only method of teaching. Okay, but this virtual world has changed the entire pedagogy. The pedagogy means the way of teaching. Earlier we used to sit in the classrooms and there used to be a teacher. Now all these things have now become a fairy tale. Okay, we remember them like it was a dream when we used to live those lives. Okay, everything has went virtual. Okay, it is expected that this industry will progress at a very fast pace. So healthcare is also something which has turned completely virtual now. Okay, my mother is being treated by a doctor who is in Delhi. He sits in Greater Kailash, and he is examining and treating my mother right from there. Everything is online. The prescription is online. There is a video conferencing. Okay, everything is going fine. The medicines are ordered online. Everything is online. So this is how everything is completely virtual. It is expected that this industry will progress at a very fast pace. It is expected that India will have 859 million smartphone users by 2022. With these growing number of internet and smartphone users, India has a huge potential for becoming the hub of mobile health industry. Okay, it is expected that India will have 859 million smartphone users by 2022. Okay, this is the data that by this year there will be 859 million smartphone users in India only. With these growing number of internet and smartphone users, India has a huge potential for becoming the hub of mobile health industry. This mobile health is also very essential. This is something very new. However, the collection of digital health data by these industries remains a matter of concern due to the weakness of antiquated laws that govern this arena. Currently, the data protection regime is governed by Information Technology Act 2000, read with the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011, which provides for a body corporate to follow adept data protection measures and in case of any breach, pay compensation to the affected person. This has, however, not been updated with regards to rapid developments in technology and leaves many aspects unaddressed. What is the issue now? The issue is that the digital health data is being collected online, but this digital health data remains a point of concern because there is a lot of legislative void in this area. Legislative void in the sense that there are no proper legal mechanisms. The antiquated laws, that means the old laws, okay, the old laws, the antediluvian laws, the outdated laws are quite weak and feeble to govern this area. Okay, digital health data is something which is very complex technologically, and it has to be dealt with equally complex legal mechanism. Okay, if the digital health data structure happens to stand on a certain pedestal which is higher than the present laws, the laws should also go somewhere on a pedestal which is higher even than that pedestal. Okay, so there are some weaknesses, there is a lot of legislative voids which are left in between, there is a lot of weakness which is involved in the antiquated laws that govern this area. Right now, what is the present situation? Right now, what is the present situation? Ananya, please don't reply to these comments. I don't know where these people come from and why do they comment. Okay. Information data protection regime is governed by Information Technology Act 2000, read with the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. Okay. Now, what is the present situation? The present situation is that the present data protection regime is governed by Information Technology Act 2000, read with Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011, which provides for a body corporate to follow adept data protection measures and in case of any breach, pay compensation to the affected person. Okay. Now, if somebody, what is the present law? What is the present legal mechanism? The present mechanism is that there is Information Technology Act 2000, which has to be read with Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data or Information Rules 2011. And this establishes a body corporate to adapt data protection measures. Okay, and in case of any breach, pay compensation to the affected person. If there is a data breach, the aggrieved person will have to be given the compensation. But these laws, these rules have not yet been updated. So far as the rapid developments in technology are concerned, they should have been updated at a much faster pace. Now, this leaves many aspects unaddressed. Digital health data in relation to PDP Bill 2019 and Disha. Now, what is the digital health data in relation to the Personal Data Protection Bill 2019 and Draft Information Security on Healthcare Act? Okay, after the landmark decision of the Apex Court in Justice case Puttaswamy retired versus Union of India. This is a case on the right to privacy. 9 judges bench, ratio is 9:0. All the 9 judges on the bench unequivocally and unanimously said one and the same thing. Right to privacy is an inalienable, uncompromisable, unfettered right under Article 21 of the Constitution. Where the right to privacy was declared as a fundamental right, efforts were made to frame a Data Protection Act in India. In this step, PDP Bill 2019 was tabled in the Parliament, which is currently being discussed and deliberated by a joint parliamentary committee in consultation with experts as well as stakeholders of the field. Okay. This was declared as a fundamental rights, and then the efforts subsequently were made for the Data Protection Act in India. When this PDP Bill 2019 was tabled in the Parliament, which is currently being discussed by a joint parliamentary committee, this complements the observation of the Supreme Court in Justice case Puttaswamy retired versus Union of India. Disha, on the other hand, has been drafted by the Ministry of Family and Health Welfare specifically for the protection of DHD. Okay. Under Disha, the user has been given the power to control the flow of his or her data at every stage of data collection, processing, storage, transmission, etc. Moreover, the user has been given the power to refuse the consent for data collection at any stage he/she wants. Note that all these steps need to be taken after explicit and prior permission from the user for every use of data in an unidentifiable form. Section 28 Disha. Okay. What is this Digital Information Security and Healthcare Act? There is a little comparative study which is done here. The PDP bill was drafted subsequent to the Justice case Puttaswamy judgment of the Supreme Court. In order to complement it, to have a mechanism to deal with the data protection in India. But what is Disha? Digital Information Security and Healthcare Act. This is drafted by Ministry of Family and Health Welfare specifically for the protection of digital health data. Okay, digital health data. PDP covers all the data in general, but Disha covers specifically DHD, digital health data. Under Disha, the user has been given the power to control the flow of his or her data at every stage of data collection. Okay. Under Disha, the user has been given the power to control the flow of his or her data at every stage of data collection, processing, storage, transmission, etc. Disha has a more advanced mechanism because under Disha, the user, like for example, I am floating my doctor's prescription on a portal. Now Disha has certain checks which it has created. Okay, that I will then be able to control the flow of my digital health informations, like where it is going, where it is being collected, by whom it is being collected, and in what form, how it is being processed, where it is being stored, and where it has been transmitted. Okay, moreover, the user has been given the power to refuse the consent for data collection at any stage he/she wants. Note that all these steps need to be taken after explicit and prior permission from the user for every use of data in an unidentifiable form. Section 28 of the Disha says that all these steps need to be taken after explicit and prior permission from the user. Like if you are floating and you're sharing your health data, your health information on a digital portal, on a digital platform, your consent is needed, your permission is needed, that it whether it can be accessed or not. Okay, and prior permission, this issue of consent is very important in the case of privacy. And prior permission from the user for every use of data in an unidentifiable form, section 28. Okay. However, the difference between the two legislation is that as per PDP Bill 2019, you need consent for the processing of digital data. Like before your digital data is being processed, your consent would be sought under the Personal Data Protection Bill. And since health data has been defined as a sensitive personal data under section 3 subsection 36 of the PDP Bill 2019, the requirement is explicit consent at only one stage, which is before using such data by any entity, section 11 PDP Bill 2019. So I hope you people are able to understand what these paragraphs says, what these lines contain. Right? See, PDP bill needs your consent for processing your digital data. And so far as your health data is concerned, it has been categorized as sensitive personal data under section 3 sub clause 36 of the PDP bill. And so the processing of which requires a prior explicit consent. Explicit means it should be like expressed by you that yes, that you consent to share your digital health information. You should give an explicit consent. What is the consent with regard to the other digital data? It's a normal consent. It may be expressed or implied, but in case of digital health, it always needs to be express consent, explicit consent. At only one stage, which is before using such data by any entity. While anyone uses such data by any entity, your explicit consent, your express consent will be sought. This is under section 11 of the Personal Data Protection Bill 2019. Okay, now let us read the provisions of Disha. Whereas if we observe section 29 clause 2 of Disha, then mobile health service providers like applications or wearable devices which collect digital health data of its customer fall under the ambit of other entity, since they aren't clinical establishment or health information exchange. As a result, they will be governed under Disha and have to comply with the strict requirement of obtaining the consent at every stage of data collection. Okay, so section 29 clause 2 of Disha says that mobile health service providers, the mobile health service providers means I told you recently like there is one Farm-Easy, there is one Tata 1mg, there are so many applications. Okay, there are so many applications. Under what category they have been put? They have been put under the ambit of other entity, okay, which collect DHD of its customer, fall under the ambit of other entity, since they aren't clinical establishment or health information exchange, okay, which collect digital health data of its customer. They are to be treated as other entity. So before they use your digital health data, they will seek your express consent before using it. This is what Digital Information Security on Healthcare Act section 29 clause 2 says. Okay, I hope you have understood. If you have any question, please ask me right away. So all these digital portals, healthcare digital portals, they will be dealt under, they will fall under, or they will be governed by Disha rather than the PDP bill, because the PDP bill does not have elaborate and extensive provisions to deal with these kinds of issues regarding healthcare. But Disha has those provisions, extensive provisions. Any question? Yes, probably net meds. That is also one of the. Okay, then I'm moving ahead. So in case of any app, wearable device that collects digital health data, if it is to be governed under PDP Bill 2019, the requirement of consent is at only one stage, that is before the processing of data by the collecting entity. Like under the PDP bill, what is the provision? Under the Personal Data Protection Bill 2019, that before any web portal collects your digital health information, digital health data, it would require that consent. Once the consent is given and once you have floated your information, now they don't require any other consent at any other stage. Okay, they don't require it at any other stage. However, if Disha is to be applied, then it has to obtain consent at each stage of data collection, from processing to that of transmission and storage. Okay, like for example, if these medical portals are falling under the jurisdiction of Disha, then Disha would make it mandatory for them to seek the consent of the person at every stage of the use of the digital health data of the patient. Okay, but PDP bill only takes the consent only once. That is before it is being uploaded at the very first stage. That is the only consent. But Disha, it has created a proper, more strict mechanism with regard to the seeking of consent. Okay. Hence, if Disha is to be applied in such a case, it will lengthen the process, limiting the use of such data as per the strict compliance requirements of Disha, which has been discussed further. Now, express ban on commercialization of health data and its impact on mobile health. The mobile health industry functions on various business models, but one of the key components of them is targeted advertisements. Okay, mobile health industry functions on various business models. Okay, various business models, like I told you NetMeds, they function on various business models. They hardly work or function as clinics. They are rather business models. Okay, but one of the key components of them is targeted advertisements. This is important for those service providers who are fully automated online and offer various services completely free for increasing their customer base and send them targeted advertisements based on user data. Consider the example of Mobisoft, which through its apps, wearable devices can collect sophisticated data like body mass index, and on basis of such data prepares a specific content tailored for a specific individual, which often comes with recommendations or advertisements for any product or company. Okay, now you can see there are some targeted advertisements. If you keep visiting some website, and if you keep logging in some app every time, then whatever website you visit, you will come across the advertisements of that website or something of that. Like for example, they have created targeted advertisements. Like if you keep visiting the the website of the NetMeds or Tata 1mg. While visiting any other website, these advertisements of of Tata 1mg or NetMeds, they will continue to pop up again and again while you are surfing any other website also. Okay, like Mobisoft. Now this Mobisoft, which is through its app of wearable devices, it collects data like body mass index, and on the basis of such data prepares a specific content tailored for a specific individual, which often comes with recommendations or advertisement for any product or company. Okay, Disha has limited the use of digital health data by other entity to only limited purposes mentioned in section 28(2) of the Act, and completely prohibited the commercialization of the DHD, section 29(5) Disha. Now this is targeted advertisement. For example, once you have shared your body mass index, okay, then it will continue to create targeted advertisements. In some way or the other, they will keep popping up their advertisements for you on your mobile screens again and again to prompt you to buy their product or avail their services. This is known as commercialization, because they are not functioning as clinics, but rather they are functioning as proper business models. If you're advertising something and if you're creating targeted advertisements for specific individuals, then definitely this is pure commercialization. Disha has limited the use of digital health data by other entity to only limited purposes and completely prohibited the commercialization of the DHD. Now, once Disha is enforced and it covers and starts governing all these kinds of healthcare portals and apps, then they will have to stop their commercialization. They are then the other entity. They cannot use your data to create targeted advertisements for specific individuals. They cannot use your health information to get your healthcare services from them. Okay, or to access their healthcare services. Since the term commercial hasn't been exactly Jazbad, same as shopping sites. Since the term commercial hasn't been defined in the Act, we need to take a look in the context of legal precedents. In Lakshmi Engineering Works versus PSG Industrial Institute, the court held that commercial means related to commerce, which means connected with or engaged in commerce, mercantile, having profit as the main aim. Okay, this is the definition of word commercial, which is explained by the Supreme Court in this case, Lakshmi Engineering Works versus PSG Industrial Institute. Okay, and we have to take a look in the context of the legal precedents, right? In the context of the legal precedents, the freemium model apps provide services and features free of cost, which means there is no commercial transaction per se. However, the use of data to send a tailored advertisement to the user for revenue can be interpreted under the ambit of the term commercial. Like if you once submitted for example, long before you submitted some digital health data or information on some healthcare portal or on a healthcare app, then they will continue to use your data again and again. They will tailor an advertisement specifically for you, and they will I'm sorry, and then they will continue to pop up advertisements, their tailored advertisements specifically for you on your mobile screens again and again, whatever website you might be surfing. But those your personal health data will continue to your personal health data will be used to create tailored advertisements. Okay, now these tailored advertisements or targeted advertisements, they also fall under the category of commercial. Okay, the freemium model apps provide services and features free of cost, which means there is no commercial transaction per se. However, the use of data to send a tailored advertisement to the user for revenue can be interpreted under the ambit of the term commercial, but unless the scope of the term is defined, it will be difficult to ascertain what commercialization of digital health data means. Hence, the scope of the term commercial needs to be defined to erase any confusion. Hence, the scope of the term commercial needs to be defined to erase any confusion. If there is a complete ban on the commercialization of health data, if there is a complete ban on the commercialization of health data without defining its scope, then it will affect mobile health service providers who use either freemium or subscription based model, as the use of digital health data for tailored advertisement or recommendation for a specific user would amount to commercial use of DHD. Now for example, what is the problem which is explained by this paragraph? Like if Disha completely prohibits and bans the commercialization of health data, and healthcare portals like NetMeds or Pharmacy or Tata 1mg, they are completely banned from advertising their services. Where will they earn from? कहाँ से earn करेंगे? What will be their source of revenue then? How will people come to know about their services, that there is some health portal which is available online? Then they will have to use some subscription based model, because they need to earn money for survival. And that is what they have opened their portal for. Understood? Further, section 29(5) of Disha has even prohibited the use and access of DHD in anonymized, that means without names hidden, section 3(1)(a) Disha form for any commercial purpose. The use of DHD in the anonymized form helps in creating data points, which helps in curating to the user's need and developing the product in tune with the current trends in the market. This will also hamper research, development and innovation in mobile health sector. Okay. Further, section 29(5) of Disha has even prohibited the use and access of digital health data in anonymized form for any commercial purposes. Like, I'm sharing my name along with my digital health information, then the portal may use my name as well as my digital health information for tailoring any advertisement specifically for me or for any general advertisement. Okay, what if it hides my name? What if it hides my name and shares my uses my digital health information for any specific or general advertisement? Section 29(5) of the Disha has even prohibited the use and access of DHD in anonymized form. That means they cannot use anybody's digital health data even after hiding his name. The use of DHD in the anonymized form helps in creating data points, which helps in curating to the user's need and developing the product in tune with the current trends in the market. I mean, this paragraph says that this should have been allowed. This will also hamper research, development and innovation in mobile health sector. Okay, what road lies ahead? In PDP Bill 2019, health data health data being sensitive personal data needs the express consent of the individual for the data to be processed, but in Disha any use of DHD for commercial purposes has been prohibited. The problem lies as to the applicability of the law, that is, which law will apply in this scenario, as both PDP Bill and Disha have overriding clauses. Okay. In PDP Bill 2019, I am repeating this, health data being sensitive personal data. This is described as a sensitive personal data. Okay. needs express consent of the individual for the data to be processed. But in Disha, any use of DHD for commercial purposes has been prohibited. What is the basic difference between PDP bill and Disha? PDP bill commercializes your health data after seeking your consent, but Disha has completely prohibited the commercial purpose. No matter what consent you, how many consents you might have given, but Disha has completely prohibited the commercial purpose. The problem lies as to the applicability of the law. That is, which law will apply in this scenario, because both PDP bill and Disha have overriding clauses. Section 96 of the PDP bill and section 52 of the Disha, they have overriding clauses like notwithstanding anything contained in any other law for the time being in force. They all start with the non-obstant clause. So which provision is going to override which other provision? Like both of them are overriding clauses. Okay. Ankita is commenting they can commercialize without personal DHD. Confidentiality of the parties. Yes, they can commercialize. That is the problem. See, commercial advertisements, Ankita, are developed across the lines of some of the informations that are received from the patients. What kind of diseases are being built, are being discovered. Okay. Then the things like PharmEasy or Tata 1mg or NetMatch, they are going to tailor their advertisements accordingly. Or they can create general advertisements. But in some cases, you know, for an update on advertisements, you need to have some information from the patient, like what is the market trend? Where are the things going? Okay. Thus, if any conflicting provisions of any other law exist, then that conflicting provision wouldn't be applicable. In such a case, the support can be taken from General Manager Telecom versus M. Krishnan, where it was observed that in case of conflict between two sets of laws, the special law, which in this case is Disha, will override general law, which in this case is PDP Bill 2019. M-Health service providers like apps, wearable devices usually do not collect or process extremely personal, complicated health data related to one individual. Ankita is commenting they can use review for commercialize their sites. Yes, exactly. They can do so. Very nice. Mobile health service providers like apps, wearable devices usually do not collect or process extremely personal, complicated health data related to one individual as clinical establishments or health information exchanges do. For example, DNA sample, data related to serious chronic condition, illness, etc. Okay. Now, this paragraph explains that mobile health service providers, they do not collect your extremely personal or complicated health data or informations. Okay. To one individual. Like for example, DNA sample. DNA is extremely personal. Or information related to any serious chronic condition. Their operation is usually limited to the collection of data like rate of heartbeat, data related to physical condition, or at times BMI of individual, body mass index of individual. Therefore, inclusion of such mobile health service providers under the ambit of Disha can negatively impact the growth of mobile health sector because of the extremely strict requirements under the Act. So the author of this article suggests that, we need to differentiate between personal data and extremely personal data. There should be prohibitions regarding the use of extremely personal data like DNA or information related to any serious chronic disease. But at times, like information like the rate of your heartbeat or your physical condition, present physical condition, or your body mass index, these are personal. These might be called personal, but these are not extremely personal. And if mobile health service providers are going to fall under the ambit of the Disha, then this is going to badly or adversely affect the growth of the mobile health sector. Okay. So Disha is negatively impacting the mobile health sector. Hence, the applicability of Disha can be limited to clinical establishments or health information exchanges only. Disha is limited to only clinical establishments or health information exchange only, because it has completely banned commercial. It does not allow any business model to grow on the lines of medical sector or health sector. Considering the nature of digital health data they handle, and apps, wearable devices providing mobile health services can be governed under the PDP Bill 2019, which will not only reduce friction between the two sets of laws, but will also promote the development of mobile health. Okay, this will also development. That means the author suggests that it should be governed by PDP Bill 2019 because it does not prohibit. And it should not be governed by Disha because it completely prohibits. If Disha is going to be applicable on them, then the mobile health sector growth will be adversely affected. So it is better that they are governed under PDP bill because it has some appropriate measures of checks and balances. Okay. So this is about the digital information security in healthcare sector. Now, if you have any question, please, you're most welcome to ask. बात जज्बात हो तुम comments, but trends involves a large number of patients' data. Is it not non-personal data? See, it is not a non-personal data, because every time you are floating your personal information or health information on a web portal, you are breaching your own privacy by your own hands. I'm submitting my number, I'm submitting my address, I'm submitting my name, I'm submitting my email ID, and then I'm submitting my health related information. Okay. Now, temporary health information can be shared. Although it is personal, there is no doubt about it that it is not personal. It is personal. But a differentiation has to be drawn between personal and extremely personal under Disha. Otherwise, Disha, if applicable, would adversely affect the growth of mobile sector because it has completely banned the commercialization. It is only applicable to clinical establishments or health information exchanges. That's it. Okay. It is a personal data, Jaswat. Okay.